Well, good morning, everybody. I'm Jeff Rosen. I'm one of the lawyers here at Cunningham Legal, and welcome to my virtual webinar, my virtual workshop. So we hold these virtual workshops. We actually host several per week, and I do about 2 or 3 per week. And so the topic today is it's easy to do your estate plan from home. And so I see the participants are going up and up. We're having more and more people join in. I'm the kind of guy that likes to start things on time, so we're not going to wait for them to jump in because I know all of you jumped on time for me, and I appreciate it. And so I'll tell you what, I've been working from home, me and my staff and the other lawyers at the firm, we've been working from home for about 4 weeks now. I think this is the 4th week that we've been doing this from home. And I know a lot of you are probably doing the same thing. Hopefully you're doing well. Hopefully you haven't, lost your job or been laid off or have a loved one who's dealing with the virus right now. If you are, I'm certainly sorry to hear that, but I'm happy that you're here today. And honestly, over the last 4 weeks, I've been able to work with several clients doing new estate plans, doing updates to their estate plans. And the overwhelming response that I'm getting from them is, oh my gosh, Jeff, this is so much easier than I thought it was going to be. We were able to do the entire process by video conferencing. You were able to send me the drafts at my house. We were able to get a custom drafted plan all together during this kind of crazy time. And in fact, a lot of my clients are saying, hey, I worked with a lawyer before years and years ago, and we did it traditionally where I met in their office and I had to go to their office to sign all the documents, and doing it this way has actually been way easier. So I kind of thought to myself, well, hey, if I were someone who either has never done estate planning before, I've never met with a lawyer before and talked about this stuff, or even if I was somebody who has had an estate plan in place for a long time, but they're just not really sure if it's up to date, I thought to myself, if I were one of those people, what would I want to see? If I could watch something for 45 minutes to kind of give me an inside look into the process of how you do an estate plan when you're at home, I think that would be really valuable. And so I decided to make that the topic of the webinar today, and I hope you guys enjoy it. We're going to go for about 45 minutes, so we're going to get you out of here before Jeopardy starts at 7 o'clock tonight. And I want to be respectful of your time. So let's see. So hopefully you guys can see me, see my face in the bottom corner of your screen. So that's me. And hopefully the bigger part of your screen is my actual presentation. So let's see here. So I am a lawyer, and I'm talking about legal stuff here, and I'm required to put up this disclaimer. And just so you guys know, today's topic, it really isn't going to be ultra technical in nature. It's not going to be about, hey, these are all the legal things that you need to know and evaluate when you do an estate plan. This is designed to kind of be a little more of an overview and a little bit more focused on the actual process involved in doing an estate plan. I want people to know, hey, this is an inside look. Before I actually become a client of yours, I want the ability to kind of see what this whole estate planning process looks like. That's the purpose of the presentation today. If you're looking for something that's a little bit more analysis-based, a little bit more technical about the laws that surround all of these things, I would suggest you check out one of our other virtual workshops, because a lot of ours are legal in nature, but this one's not really going to be. So I'm a lawyer, and even though I'm not talking about technical legal stuff, I still want to make sure that you guys understand that what I'm doing today, I'm not really giving you legal advice. I really intend to talk about these things kind of from a 30,000-foot level, and I hope that this is helpful for you to hear, but I don't want you to go off after you hear my presentation today and decide to sell your house or sell the vacation home because of something you heard me say today. So where legal advice actually happens is when you meet with a lawyer one-on-one, whether it's in person at the lawyer's office, at your home, over a video conference, on the telephone, that's where legal advice happens. And so one of the things that we're offering each one of you today for attending is, after this presentation, you have the opportunity to schedule a free, no obligation consultation with me or with one of the other lawyers at the firm, and we can kind of go over the things we talked about today in a little bit more detail. So that's a legal disclaimer I'm required to put up there. Now, If you have any questions, you know, I want to be respectful of everybody's time on here, so I'm not going to take any questions during the presentation itself, but on this Zoom platform, it is really cool. They have a chat box, and so if you do have a question, feel free to put something in the chat box there, and at the end of all of this, I will answer as many questions as I can. Now, a little bit about me, not too much about me, because really this isn't about me, this is about you guys, but that's a picture of me. And I am actually a second-generation estate planning attorney. So my grandfather, who retired recently, was also a family law and estate planning lawyer. And so I really developed my passion for this area of the law really early on from watching him and how much he enjoyed his career. I grew up in Los Angeles. I'm one of 7 attorneys here at the firm, and all 7 of us lawyers specialize in this particular area of the law in estate planning. And I began my time with the firm. I've been associated with Cunningham Legal since 2014. So I can't believe it was that long ago that I first started working with Jim Cunningham, but time really flies. And one interesting thing about me is I recently passed an exam to become what they call a California Certified Specialist in Estate Planning, Trust, and Probate Law. So this is essentially a second bar exam that lawyers can take, and less than 1% of lawyers become a certified specialist in their field. There are about 8 fields that you can become a certified specialist in. And even though I technically am not a certified specialist right now, I have passed the exam, and after I get a couple recommendations from some judges and some peers that I have to submit in the upcoming months, then I'll be able to call myself a certified specialist. So I'm really proud that I don't have to take that exam again, because it was tough. So why are you here today, guys? Well, number one, you're probably at home, right? Most of you are probably watching this from home. And I know 4 weeks ago or 5 weeks ago when the governor put the stay-in-place order, I think a lot of people, if you were anything like me, you were kind of looking forward to working from home, right? I think a lot of us kind of thought it was going to be like this. It was going to be, hey, you know, I get to have breakfast in bed. I get to spend all this time with my family and get some work done at the same time. This is going to be great. And if you're anything like me, it's not like that. It's actually a little bit like this. So I have a 2-year-old at home, and dealing with her is actually, I shouldn't say dealing with her, but getting to spend time with her has been fantastic, and I've been able to help my clients at the same time. So I don't really feel like this guy, and I hope you guys don't either. So you're here today because you're at home, and you need to do this now. You need to have an estate plan set up now. And I really don't think it matters if you're a person who has an extraordinary large estate, or you have a very modest estate, or if you have a big family, or if you have no family at all. Wherever you fall into that category, I really don't think it matters. You need to have an estate plan that's properly done for you. And so the purpose of this meeting is to explain to you, this is how easy it is to do it from home. And every one of you listening, even if you are an 18-year-old, which I doubt I have many 18-year-olds on here, but if you are, you need to have an estate plan. And when you do it, you really want to have a qualified team behind you. This is not something you want to give it a go on your own. And so a lot of people ask me, well, Jeff, you know, if I'm going to do this online, if I'm going to do it, you know, video conferencing with you and everything I can do from my house, well, why should I work with an attorney? Because I have the opportunity to do that already. I can go on LegalZoom. I can go on a website that offers this. Why do I have to work with a full service law firm to accomplish this? And here's my answer. It's really simple. Your estate plan has to do with everybody you love the most in the world and everything you have worked a lifetime to accumulate. This is one of the most important things you will do during your lifetime, and it has to be done properly. And if you use LegalZoom, I mean, I actually am a fan of LegalZoom. I think it's really cool. You can go on there and get a document if you need to. But when it comes to estate planning, this stuff is just so easy to not get done correctly. And there are tax consequences involved, and the harmony of your family after you're gone is involved, that it has to be done correctly. If you try to do it yourself, if you Google the word living trust, 32 million results come up. This is not the kind of thing you should give it a go on your own. You need to get some expert help to guide you through this. And so when you do an estate plan, with my firm at least, it is generally a 3-stage process, and it takes about 3 weeks. So each one of these stages takes 1 week to accomplish, and at the end of it, after 3 weeks, you have a custom tailored estate plan for you. And so typically where you start off is step one is having a consultation with a lawyer. So having a consultation with me or another one of the lawyers here. And typically nowadays, since we're not allowed to meet with people in person, we're doing that over video conference, we're doing it over telephone calls. But the important thing is you're doing it with a lawyer. Unfortunately, I don't think as many of my colleagues have been as well situated as we have been to kind of absorb this transition to working at home temporarily. I think we've always kind of been technology based, and so this has been a real easy transition for us to make, whereas some of the other law firms around me I know are unfortunately furloughing their employees, or they're just not doing business right now. So I'm proud that we're a firm that can still help its clients and its potential new clients. And so after you do your consultation, kind of skipping ahead to step 3, that's when you sign all your documents, right? So obviously you're going to have to sign all of these estate planning documents. And what we do there is we deliver them to your home, and everybody that I work with right now is signing their documents at home where it's safe. And we're going to go over kind of the details of how that works. And then in between, kind of what you do after you do a consultation is it's time to draft the estate plan and review it with your attorney. So when I say estate plan, really what I'm talking about is all the documents that go into creating your plan. And so your estate plan is a compilation of all your legal documents that are going to come into play when something happens to you. When you either get too sick to do things on your own, we call that becoming incapacitated, or when you eventually pass away. So a lot of people I work with are going to do a living trust. They're going to do a will, a power of attorney for financial matters, a power of attorney for healthcare matters. They may have to deed their house to their trust. And so all of those are things that we go over when we draft an estate plan and we review an estate plan with our clients we're working with. And if you're sitting there and you say, well, hey, you know, this kind of sounds like this is for people who have never done this before, and I already have an estate plan, I still think that this is valuable for you to tune into, because it may have been a long time since you did this, and you may have never engaged doing this through video conference before. And I think you're going to be pleasantly surprised how easy it is to get this done. So step 1, having a consultation with a lawyer. And frankly, your estate plan, the way it gets set up, it needs to reflect your unique story, right? So not every person should have a trust or a will or some kind of planning document that looks just the same as everybody else. And I think when you're not working with a lawyer, even when you're working with a lawyer sometimes, unfortunately, that's what you end up with. You end up with a cookie cutter document that really has the same provisions for everybody who's using that document, and they're not really tailored towards the needs of your family and the things that are important to you and what I would consider your story. So one of the primary reasons for doing the consultation with a lawyer is to determine what your story is and to find out, hey, based on all of these things that are important to you, this is the language that needs to be in your trust. This is how we need to structure this estate plan to accomplish that. And the ways I've been communicating with people over the last 4 or 5 weeks, which has been going really well, is number 1, Zoom. So Zoom is what we're using right now. I love Zoom. It is a fantastic way of communicating. I think they've been getting some, you know, you may have heard in the news that they're having some, I don't know what you would call it, data breaches or something like that. But as far as everything I've read, this is still a very secure platform. And the level of Zoom membership that we have is one of the highest levels you can get. I'm also using FaceTime with people. So people who can't use Zoom as easily, who aren't as computer savvy, but if they have an iPhone or an iPad, we can jump onto FaceTime. I use Skype as well, and you know, I use old-fashioned telephone as well. That works just as good. I put a little rotary dial phone on there. You know, if you're younger than me, you probably don't even recognize what that is. I'm afraid that my daughter is probably going to grow up not even knowing what that is. So I know you've all successfully logged on to Zoom today, or else you wouldn't be watching this. But I wanted to just kind of show you, this is what the home screen looks like for Zoom. So if you're kind of averse to using this, if you say, oh, you know, this is so futuristic, it's so difficult to get logged in here, Zoom makes it incredibly easy. So what you do is you just go to Zoom's website, you follow a link that I send you, You punch in the meeting ID code. I put it in for happy client here, and you join, and as soon as you click join, what do you see? You see this good-looking guy. And my face pops up, and we're really, in my experience, able to have a meaningful discussion. And after a few minutes of doing the interaction through video conference, it actually kind of feels like we're face-to-face. And when I started doing these virtual meetings, initially last month, I said, well, you know, what I like about meeting with my clients is I meet with them in person, and we develop this personal connection, and we can communicate real easily because we're right across from one another. And I was afraid that that was going to be lost a little bit through video conferencing. And what I'm realizing is it's not lost at all. We can actually communicate really well, even though we're not in the same room together. So when you're thinking about having a consultation, what should you prepare beforehand? What should you come into the meeting having already thought about? Now, obviously, you're not going to know all the things that you need to think about. That's one of the reasons you're meeting with a lawyer, right? Because the lawyer's going to ask you questions, and they're going to invoke certain responses, and they're going to encourage you to think about certain things that you may not have been thinking about before. That's one of the advantages, one of the main advantages of working with an experienced lawyer. But what should you be thinking about before you even talk to me or another lawyer at the firm? Well, most of my clients are going to be creating a trust. And you are generally what they call the grantor of the trust. You're the creator of the trust. And you're also what they call the trustee. You're the manager of the trust. But if something happens to you, if you get sick and you can't serve as the trustee anymore, or when you pass away and you can't serve as the trustee anymore, you need to designate who the next manager is going to be, who the successor trustee is going to be. And it's one of the most important decisions that you make when you engage in the estate planning process. And frequently I meet with people and I say, well, you know, hey, who have you thought about your successor trustee? Who's it going to be? And sometimes people I'm meeting with, they say, well, I have no idea. I've never even thought about it before. And this is one of those things that it's a good idea to think about it before, because it's so important. And when you have an initial consultation, you don't have to have the answers to all of this immediately, right? As we go through the 3-week process, we may be able to identify as time goes on who the appropriate trustee would be. But I think this is something you should be thinking about right now. If you have an existing trust and there are existing successor trustees in there, you should really be thinking about, hey, are these still the appropriate people to do this job? Because the person you choose needs to be as trustworthy as they come. They need to be capable of getting the job done, which means they need to not necessarily have done this before, but they need to be financially savvy enough to understand, hey, I got a big responsibility here. I got to manage the assets that are in this trust, and I have to do it responsibly for the beneficiaries. And I think one other thing to weigh when you're making this decision is geography, right? Because your trustee is going to come into play and carry out your wishes when you pass away. And if they live in New York, you know, they could probably take a flight over here, and maybe 1 or 2 times traveling over to where you live, they can get the job done. But this is also a person who's going to serve in a period of your incapacity. And it's not outrageous to kind of predict that there could be this 2, 3, 4-year window of time that we exist in where we're not managing our trust anymore because we don't have mental capacity, and somebody else is doing that for us. And if you name somebody who's not that close to you, then it can become a real challenging job to get that done. So what should you be thinking about before you come into your consultation? Who the right person to do that is. Another thing that you should be thinking about is who your beneficiaries are going to be. So who are the people who you want to leave an inheritance to? Is it going to go all equally to your family members? Is it going to go to your kids? Is it going to go to charities, or are you going to spread it out among several different institutions? You don't have to have it entirely nailed down when you come into your consultation, but I do recommend at least be thinking about it. Think about narrowing a plan down to reflect what you really want to accomplish with this trust. Now, a couple of other things that I think you should be thinking of. We went over beneficiaries. We went over trustee. Why do I have a picture of Tom Hanks here? Why on earth is Tom Hanks on this slide? When I think of the most trustworthy person I can imagine, for some reason, I think of Tom Hanks. I would have no problem naming Tom Hanks as the trustee of my trust. I know he would do a good job. And so you guys need to find your Tom Hanks to do that job for you. You should also be considering, hey, who do I want to be the manager of my finances? Who should be making healthcare decisions for me if something happens to me and I can't communicate with my doctor anymore? If you're a person who has minor children still, like me, you should be thinking, hey, who do I want to nominate as the guardian for my youngsters if something happens to me prematurely, right? I want to have a say in who watches over my kids if I pass away. A lot of my clients are business owners. They have to think about, what do I want to happen to the business if I pass away, right? Who's going to take it over? Who are the other parties involved? Is my spouse going to be able to take it over? Are they going to have to sell it to my partners? That's something that you should be thinking about. If you're married, what happens after one of you passes away? Chances are one of you is going to pass away before the other, and what provisions should be in there that govern what the surviving spouse is allowed to do with the trust? Should the trust remain revocable? Should the surviving spouse be able to change it whenever he or she wants to? Or should a portion of that trust become unchangeable after one spouse passes away, so the surviving spouse can't rewrite it and leave everything to the cabana boy or the cabana girl? Managing an inheritance. Are you going to leave everything you've worked hard to somebody who's 20 years old and is going to blow it at the local sports car dealership? And who determines incapacity? How do you want it to be determined that you're not capable of managing your trust anymore? So these are all the things that I think are helpful to think about before you come into the consultation. And as you go through the consultation and you meet with the lawyer, these are the things we'll be talking more and more about. And frankly, this is not an exhaustive list either. There are plenty more things that come up in a consultation, but these are a good starting point for when you get ready to do that. Now, as far as continuing to prepare beforehand, a lot of people, the feedback I'm really surprised to get is people say, Jeff, you know, I've been putting off doing my estate plan for so long because I'm afraid it's going to take so much time, and you're probably going to require all these documents from me. I'm going to have to get all my records from the last 15 years to give them to you. And, you know, I just don't have time to do all of that right now. And so people keep putting it off and putting it off because they're afraid of all the work that's involved. Hopefully what you can gain from this webinar today is that it's actually not that much work on your part to do this estate planning. For your lawyer and for your legal team, they're working really hard to get this done. But for you, there's not much you need to do. So what do you need to provide to the lawyer? Well, one of the things we do when you decide to set up a free consultation with us is we send you a confidential questionnaire. And it's about 8 pages long, and it asks for a general overview of your family, a general overview of some of your assets. And basically, we need to know what your estate is made up of so that we can do an analysis of your estate, right? And that's the best starting point possible. So I've realized that my clients and my potential clients who set up a free consultation with me, the ones that get the most out of it are the ones that fill out that questionnaire really well. Usually it takes about 45 minutes to fill out that questionnaire. If you have any existing estate planning documents, it's really helpful for me to see those beforehand. So you may need to make a copy of those and mail them to my office where I still pick up the mail, or you can email them to me. We try to make it really easy. We can also send you a link so that you can upload them to a confidential server. And a little bit about this word confidentiality, because I think it's really an important point to make. So when you meet with a lawyer, and you have a meeting with him or her and you discuss things with him or her, everything you share with the lawyer, except for, you know, maybe some minor exceptions, but for the most part, everything you share with that lawyer, whether you hire the lawyer to do a service for you or not, if you just have a free consultation with them, everything you share with them, you say, everything you mail to them is all confidential. That lawyer may not share that information with anybody. So sometimes I have people a little reluctant to send me stuff. They say, well, you know, if you need a statement of my bank account, well, you know, what are you going to do with that, Jeff? Are you going to sell that to people on the third market? Are you going to, you know, do bad stuff with it? And the answer is, even if you don't hire me, I am duty bound to you to protect that information the best I possibly can. And we all take that very, very seriously. And so that's really the extent of the things that you need to provide to us. We may need to see a financial statement. With a lot of my clients, it's a good idea for me to look at them, but it's actually not a necessary part to setting up the estate plan. And that surprises a lot of people. What I'm trying to drive home here is it's really not as complicated as people think. And so our goal, when we have the consultation, our ultimate goal is this. After about an hour and 15 minutes of meeting with somebody, in most cases, I'm able to develop a custom designed game plan for getting a new estate plan set up or updating an older, outdated estate plan. And after I have an idea of all the things that are important to you and how we're going to structure the estate plan and what you want to accomplish, I'm able to present you with a flat fee proposal for how much it would be to do the work. And so one thing I'm really proud of is that whenever I can, I do my work on a flat fee basis. I've had to hire lawyers here and there for odd things before, and they've always charged me on an hourly basis. And I got to tell you, it was always so nerve-wracking because I wouldn't want to call them. I knew the meter would be running. And so most of the time I just said, well, hey, even though I'm not an expert in this area of the law, I'm not going to ask my lawyer because I don't want to get that bill for $250 next month. And it had a real chilling effect on me. So the reason I like doing things on a flat fee basis is you already know at the very beginning, this is how much it's going to cost to do all of this work. And if you need to call me and ask me a question or go over a draft with me, you already know, even if it takes 2 hours to do that, you're not going to be getting an additional bill in the mail. And that's the way I like to work whenever I can. So step one is do a consultation. Step two is drafting the documents and then reviewing them. And generally, we're able to deliver a customized estate plan, the rough drafts, in about 2 weeks. So about 2 weeks from the date we get started, we're able to get rough drafts over to you to see them. And with most of my clients who are kind of computer savvy, we're able to email all of the rough drafts. So they're able to look at them on the computer. They can print them at home if they need to. But I still possess the ability, if you're, honestly, if you're a little bit like me, you still like to look at hard copies of stuff. And if that's the way you are, we still have the ability to print documents and send them out for your review. So all of our clients have the option of how they like to receive them. And so here's what things typically look like. So you receive your drafts at home. They get there in about 2 weeks. And one of the reasons we're sending them to your house and we're not saying, hey, come to the office and pick them up is we really care about your safety. We want to make sure that you're not exposed to anything on the way over to our office. We really want to mail these to you or email them to you. Now, after you've had a chance to look at the rough drafts, generally what you'll do is you'll get a call from one of our paralegals on the team who knows your matter backwards and forwards, and we do what's called a clerical review call, where you have an opportunity to ask any questions that developed as you looked over the drafts with an experienced paralegal. And after you've gone over everything with the paralegal, if we need to make changes, we'll make the changes. If everything looks good, then we'll note that it all looks good. Ultimately, you're going to have a follow-up with your lawyers. So if you're working with me, for example, after that clerical review call, if anything needs to be addressed, if any changes need to be made, if you just have any questions and you say, Jeff, hey, I read this one paragraph on page 7, I read it 5 times and it still doesn't make sense to me. Can you explain what it means? That's one of the advantages to working with a lawyer, right? Is you get to ask those questions. You get to custom tailor this thing and make sure that everything you want comes across in that document, because once you're gone, it's the document that lives on, right? We don't have the opportunity to come back to you and say, well, hey, what did you actually mean by this provision here? The document is going to have to speak for itself. And so you communicating with the lawyer and the lawyer using his or her expertise to get and communicate your wishes into that document is one of the most important things in this entire process. And that's why we're so proud that we do this review process. If you're the kind of person that's using LegalZoom or something, you're just kind of stuck with what you got, right? You're stuck with what they send you, and you don't really know if those provisions are going to capture your wishes. You don't really know if the inheritance is going to go the way you want it to go, for example. Ultimately, this leads to you having confidence. And I won't let any of my clients, after we have our review, after you've seen the rough draft, if you're for some reason still not confident in the documents we've prepared, I'm not going to let you sign them. You have to feel confident in all of the decisions you've made. You have to feel confident that you understand what the documents say and the consequences of the things that you put in there. And that's really what my role is. My role is to help you develop confidence and to help you confidently move forward in creating this. Now, this is kind of a funny picture. I know a lot of my clients, you know, that's a really old person's hand. A lot of my clients aren't, you know, as wrinkly, I don't know. But I wanted to put this here because, you know, we're going to hold your hand through this process. You're not going to be alone. We're going to be here and guide you throughout everything. But at the same time, you know, you are the hero of your story, right? So this is a Captain America shield. And when I work with a client, I'm not the hero, right? I'm not the one who's saving the day. I'm not the one that's putting this plan in place to protect you and protect your family. That's you. You're the hero of your story here. And as we go through the draft review and the review process, I want all of my clients to know, hey, you're the star of the show here. You're the one that calls the shots, and I'm here to guide you to getting this to be the document you want it to be. So finally, after doing a draft review process, and we're able to do it all easily while you're still at home and you're still safely there, and we're communicating on video conference or the telephone or email, however it works for you is how we're going to do it. Eventually, it becomes time to sign the document. So obviously, you're going to sign these documents eventually, right? And that typically happens about week 3. So 3 weeks from getting started. Sometimes we push it out to 4 weeks if you need more time to do the review process. But ultimately, you need to sign these documents. And consistent with everything we've been talking about here, you're going to sign everything at home. So we are going to print every document once we get it just the way you want it to be. We're going to print everything. We're going to mail it to your house overnight. We're going to schedule a signing date that you're going to sign everything. And we're going to tab each page that requires your signature. And then when it's time to actually sign them, you're going to have the guidance of your attorney. Your attorney is going to be on the phone with you, and he or she, if it's me, I'm going to say, all right, this is your trust. This is where you sign it. This is a quick overview of the documents, so that if you do have any questions at all, we're here for you to answer them. Now, traditionally, when my clients sign their documents, we have them sign them in our office. And my paralegals are all licensed notaries, and we notarize your signature in our office. Right now, that's a challenge, right? Because we have this stay in place order. We don't want to be exposing our clients to any risks. And, you know, frankly, I don't want to expose any of my staff members to any risks. I care deeply about everybody involved in this process. And so we have you sign at home. Now, you may have heard that when you sign legal documents like this, it's typical to notarize them. You may have heard that some of them are witnessed by people. And those are all still things that are good to have. Now, when you sign a will, for example, a will typically is not notarized. Typically, you have 2 people witness your signature. Now, obviously, if you're signing from home and you're doing social distancing, it is probably going to be challenging to get these documents notarized, right? Because, you know, you can't have a notary come to your house. Most of them aren't doing house calls anymore. Sometimes you can go to your bank and your bank will notarize documents, but I've heard people not being able to get that done. Now, when you sign your trust, the moment you sign it, it's a valid document. If it expresses your intent, it's a valid document. It doesn't have to be notarized in order to be a valid legal document. But it is a good idea. Remember, a notary verifies that that signature belongs to you. You're the person who signed this document. It wasn't anybody else who was trying to commit fraud or forge your signature. And if you have a trust that has real estate in it, it's a really good idea to get it notarized. So here's what we're doing with all of our clients right now. We're having you all sign the documents at home, and we're going through each document. And one thing the attorney does is they're going to do what's called a declaration. And a declaration is basically something signed by an attorney that says, hey, I swear under penalty of perjury in the state of California that everything I'm saying in this declaration is true. And we declare that we were on the phone with you as you signed it, and you expressed to us after you signed each document. And if you need to use the documents before you have a chance to have them notarized, you can show that declaration from your attorney, and it will increase the ability for you to be able to successfully use those documents. Now, with all of my clients that we're working this way for, once the social distancing is no longer a requirement, once it's safe and you feel comfortable to come into our office, we're going to have you come to the office and we're going to notarize all your signatures. Now, a lot of people think that when you notarize something, you have to be sitting there with the notary and they have to witness you do your signature and then they can notarize it, because that's how most of us get things notarized. And, you know, most of us aren't notarizing things all the time. But when it comes to a notary, you actually don't have to be there when you originally signed the document. It's completely appropriate in California to be able to sign the document, and you could take that signature page to a notary. You could take it to them 3 months later, and the notary can acknowledge your signature, so long as you say, hey, that's my signature right there on this page. And so that's what we're doing with our clients right now. There's going to be this temporary window where it's not notarized, but as soon as it's safe, you're going to come to the office and you're going to notarize it. So sometimes I explain that to people and they say, well, gosh, you know, if I can't notarize it, why don't I just wait until this whole COVID thing blows over? I'll do my estate plan once it's safe and we don't have to go through this, this process. I got to say, that's probably not a good idea, because if you're a person who needs to have an estate plan, it's going to be much better that you have it now than just wait and maybe something happens to you and you end up really needing it, but you didn't do it because you put it off. And so I would tell you with total confidence, in fact, we've interviewed a judge about this in California, a retired judge, about what we should be having our clients do right now when they need to do an estate plan. And this encompasses what his recommendations are. So ultimately, when you come back and you notarize everything, we're going to put everything in a leather-bound estate planning portfolio for you. It's going to be organized. It's going to be a really nice presentation. And think of that portfolio as what your loved ones are going to have to find after something happens to you. So all of your important stuff, all of your legal documents, if you have a burial plot that you've paid for, that information should be in this portfolio, because eventually when you're gone, this is what everybody's going to be looking for. So you want to make sure that it's easily findable, and we make it very organized so that it's easy for the person who comes next to go through that binder. Now, really quickly, if you're a person who's never gone through this process before, I thought, you know what might actually be helpful is if I just showed you, hey, this is an example of a trust that we would email to somebody. And this is what it looks like. And you would kind of, when we do our draft review, you would have it in front of you, and we would be going over it page by page during our draft review process. So temporarily, I'm going to suspend my slideshow here, sharing my screen, and instead I'm going to put something else up here. So bear with me just a moment, and I think this is going to be worth it, guys. All righty. So okay. So hopefully you guys can see a document that says the Rosen Trust from 2017. And this is actually one of my old trusts. This is a rough draft of an old trust that I had. And I've since updated it. It doesn't really have any information I wouldn't want anybody to see on here. But this is really what a draft of a trust looks like. You'll see it has a table of contents. And this is something you would go over with your attorney or your attorney's paralegal on the telephone. It has an introduction to it. The most important section of a trust is typically Article 3. Article 3 talks about who the successor trustee is. And so all this language that you see on here, I know I'm scrolling through it real quickly and you can't read any of it, but all of this language is important provisions that goes into somebody's trust. And so a trust, if you're a married person, your trust may end up being 60 pages long or 70 pages long. And a lot of people say, well, gosh, this is really a complex document. Do I really need all this language? And the answer is, no, you probably don't, but it's good to have it in there because this is a document that's going to have to be used sometime in the future at an unknown time when all the factors are unknown. And having language in there that contemplates all these potential scenarios is a real valuable thing. So, you know, I don't want to do an analysis of this draft of my trust I did several years ago, but I just wanted you to have an opportunity. If you've never done this before, I just want you to see, this is kind of what a trust looks like. This is generally what you can expect to have, something that looks a little bit like this when you engage in this process. So this is the section that talks about who I'm leaving an inheritance to. It says I'm leaving it to my daughter. She has to reach 25 years old before she can manage anything that we worked hard to leave her. So I'm going to go back to my slideshow, and I hope that was somewhat valuable. I know that for some of you, you've probably seen a trust before, so that wasn't too helpful, but I hope for some of you it was. So let's see. Getting back to our slideshow here. All right, so I hope we're back on the slideshow and you can see that we're on number 3, signing. And really remember, guys, this is a 3-step process. So remember, number 1, you have a free consultation with the lawyer, and the lawyer goes over with you, hey, these are all the things that you should be mindful of. You know what you should be thinking about before you have that meeting with the lawyer to get the most out of that free consultation. The second step is the lawyer starts drafting things, and about 2 weeks after that, the lawyer will send you out a draft so that you can review it. Now, you'll have an opportunity to review it on your own, and you'll also have an opportunity to review it with your team here at the firm and make sure you're confident in it. And once you feel confident, you're going to sign all the documents at home. And remember, all of this is really easy to do from your house. I'm actually rethinking the way I'm going to be practicing law even after this whole COVID-19 experience is over, because I think a lot of people are going to find value in doing this. So for example, if you're somebody like me who, I work full-time and my wife works full-time and we have a youngster at home, and for us to do anything, to get both of us available at the same time is really difficult. And when we need to go somewhere, it requires a high level of coordination, right? If we're going to go to the grocery store, we have to whip out our calendars and we have to say, oh, well, does Thursday at 3 o'clock work well for going to the grocery store together? And what I'm seeing more and more is that this way of communicating is making it much easier for people to do this who have really busy lifestyles. And for me, at least, if I had the opportunity to meet with somebody on video conference and I didn't have to leave my home, and I can get all of this done from the convenience of me being home, and we don't have to coordinate, hey, we're going to be here on this date, I think that's really valuable. I think that's really a great thing. And it's almost been a blessing in disguise being able to realize how easy it is to do this process, I guess non-traditional, right? Now, I did say that there were 3 things, and this is one of the last things that I'm going to go over here. I did say there were 3 steps. Now, there is a 4th step, and the 4th step is called funding your trust. So I'm not putting this in here as a surprise or anything, but I just want to make sure that it's very clear that when you do a trust and you sign all the paperwork and you sign your power of attorney and your will, that's great. That's really arguably the most important step. But the next important step is to fund your trust. So if you have a trust, some of your assets you need to transfer into the name of your trust. So I put this diagram up here a little bit earlier. When you create a trust, you're taking your bank accounts, for example, and putting it in the name of your trust. You're taking real estate and you're putting it into the name of your trust for most people. And the way you do that for real estate, for example, is I would create a deed for that real estate. So we would transfer the real estate into your name as the owner of the trust. And that's a document that needs to be signed, it needs to be notarized, and it needs to be sent into the county. So I want everybody I work with to know that this is something that is top of mind to us. Funding your trust is a very critical thing. We provide as many documents as we possibly can so that when you call your bank after you sign all the legal documents, you can say, well, hey, my lawyer gave me these documents. He said that I need to put this bank account into the name of the trust. And these are all the things that he said you're going to need to see. And I want that to be as easy as possible for you to be able to provide those things. So funding your trust, very important. So overall, I want to show you guys this little chart here because it really highlights our quality control process. So we go through 12 steps with each one of our clients. And that's how we end up with clients who have successful estate plans, right? We want to educate them. We want to get the facts from their confidential diagnostic form, their questionnaire. We want to have the consultation with a lawyer. All of our lawyers stay up to date on all the latest laws. We do training every single week, every single Monday. All of us lawyers get together and we learn new things. We draft the trust documents. We do all these steps to ensure that when you engage in this process with us, we're getting it right. Because remember, this deals with everybody you love the most, the causes that are most important to you, and everything you worked your entire lifetime to accomplish, not accomplish, but to accumulate. And that's what we are dedicated to protecting, your legacy, right? And making sure you're taken care of if you get sick. So what others do in the middle column here, you know, I think a lot of traditional law firms do this. Maybe you have a meeting with a lawyer, they process some documents for you, they give you a cookie cutter trust that they do for every one of their clients, and they send you the documents and, you know, say, hey, you just got to figure out where to sign, right? Unfortunately, I think that's what happens way too frequently in my area of law. Now, if you go to another individual, if you go to a non-lawyer, if you go to a paralegal service who advertises that they do this, or if you do legal Zoom, you know, all you're really going to get is the documents, right? You're going to get a form to fill out, and that may not accomplish what your actual wishes are. And so I'm really proud that we go through all of these steps, and it takes time, right? It takes 3 weeks to go through this process. We're going to have several video conferences with you or telephone calls with you over the course of that 3 or 4 weeks. But that's what it takes to do this right, and that's what we're committed to. So all in all, guys, I know that this really wasn't highly technical, right? I didn't talk about property taxes or inheritance taxes today. I really just wanted to give you guys an overview of this is what you can expect as you go through this process. And I certainly hope it was helpful. I hope you find it encouraging. I hope you find this motivating, because I want to make this as easy as possible for you. And I want every one of you to take me up on my offer to have a free, no obligation consultation with me. And we'll do it over the phone, we'll do it over video conference, we'll do it however works for you. But ultimately, I want to make it easy for you. So how do you make it easy? How do you set up a free consultation with me if that's what you want to do? After this webinar, you're all going to get an email to the email address that you registered for this through. And it's going to give you the opportunity to click a link and schedule a free appointment with me. It's as easy as that. In that email, you're also going to get a coupon code. You're going to get a discount of $200 for any full estate planning service. So that's creating a new estate plan or doing a restatement of a previous estate plan. If you make your appointment today with me, and not to meet today, but if you schedule your appointment for the following weeks today with me, that's how you get that $200 discount. So I really hope you found this helpful. We're going to move on to a Q&A in a few minutes, but if you need to get out of here, thank you for joining. Tune into our next webinar if you have found this one helpful. And I look forward to meeting with all of you on Zoom or Skype or old-fashioned telephone or FaceTime or whatever works. And I'm looking forward to showing you guys really how truly easy it is to do this estate planning from the comfort and safety of your house. I hope you're all doing well. Let's move on to the Q&A. I think I see some in the question and answer box. So let's see. The first question I got is, do I work with clients in Florida or only California? That's a fantastic question. So our law firm is based in California, and all of us lawyers are licensed in the state of California. So lawyers get licensed in each individual state, right? And we're all California lawyers. But I have clients all over the country. I have clients all over California. I have clients in Florida. I have clients in New York, you name it. Now, if you are a resident in a state other than California and you don't really have a connection to California, so for example, if you don't own any real estate in California, if your successor trustee doesn't live in California, if you just have no nexus or connection to California at all, it may be more appropriate if you saw a lawyer in your state. But there's no law that prohibits a lawyer in one state to draft an estate plan based on the laws of another state. So theoretically, even though I'm just licensed in California, I could draft a trust for a resident in Florida, and I could draft it under Florida law, so long as I was confident that I understood the ins and outs of Florida law. So that's the answer. Thanks for that question. Does the declaration of the signing, so the declaration that the attorney signs that I went over, does that become bolstered? Does that become more meaningful? Is it better evidence if I watch my client sign via video? You know, I think it's hard to say yes or no to that. I think most likely it's better if the signing appointment is on video. What I've had some of my clients do is we're signing on the video and they're actually holding up each page, and I take a little screenshot of each page that has their signature on it. So I do that for my clients who are just a little extra nervous about temporarily signing it without a notary. Ultimately, I think all of you are going to be getting it notarized, so it may not be required to do it that way, but certainly a good question. Next question here, and I think I have 3, and I should be able to get to all of them, and hopefully you're all still engaged here. So once a living trust restatement is done, and to avoid confusion, what information should be kept and shredded from the previous living trust? That's a great, great question. So when you do a formal update to an existing trust, typically you do what's called a restatement. And technically a restatement is, it's a formal redo of the old trust. So most restatements will completely supersede the prior documents that came before it. Now, if you do that, is it safe to throw away all those old documents? Because estate planning portfolios, they're pretty thick. A lot of people say, oh, hey, do I have to keep on holding on all these records if I don't have to? I would say, technically, you don't need to keep anything that's been legally superseded, but I would still recommend keeping it just in case, because you never know what might happen. Those new restated documents may end up being lost in the future, and then we really need to see what those old ones said. And so even though it's kind of a pain in the butt to keep all that paperwork, I recommend doing it. And if you absolutely don't want to keep it, I can go over with you what can be shredded safely and what you just really have to keep. I appreciate it's better and safer not to do it yourself. My mother, unfortunately, on that question, if you're the person that submitted that question, I can't read the rest of it, so I'm sorry I can't answer it for you. This is a question I get asked very frequently. How much approximately does it cost to do a simple trust with, you know, pretty standard factors, nothing really crazy going on with the family, no crazy assets or anything? And I have to give a kind of a frustrating answer to that. So a lawyer is not really allowed to give like a blanket price that they charge for this kind of thing. Really what we're required to do is have a meeting with an individual or a married couple or whoever and kind of determine how much time it's going to take. And then we can come up with a fee that matches the amount of time we suspect the engagement to take. And so, you know, as far, if I can give you a ballpark that would be somewhat helpful, I would say to do a trust for a married couple may start, you know, for a very basic estate plan will probably start around $1,900, and it can go as high as, I mean, it can be as high as $5,000 or even $6,000. So one thing I will say about us is that we're not the cheapest firm in town or in the state, but we're not the most expensive either. I think we fall right about in the middle for how much our fees are. If you compare us to LegalZoom, our fees are, you know, certainly higher than that, but that's because of the attention you get from the lawyer and the expertise that the lawyer has as they guide you through this process. So I would say our fees are very competitive in this field. And let's see what we got here. Oh, shoot, it looks like I have some comments from the very beginning. Someone had trouble logging in, and I'm sorry I wasn't checking this earlier. I hope you were able to get logged in there. And so actually I see that usually when I do a Q&A, I see the participants kind of drop off and people say, oh, you know, I don't want to hear the Q&A session. But it looks like most of you have stayed on. So I think that's fantastic. That tells me that at least something I said today you found interesting. So let's see, the last question I see on here, and then I'll let all of you get out of here, is, may I follow up with you directly regarding my mother's estate planning? Yeah, that's another really good question. So I get asked this very frequently, and I am happy to have a phone call with anybody who wants to discuss their parents' estate plan or something going on. I would recommend that you call us, and you can get on the telephone with a lawyer right away, and we'll spend about 15 or 20 minutes figuring out if that's something that we can help you with. Now, a challenge when it comes to being concerned about your parents' estate plan is a lot of times you as a child, for instance, you don't really have the legal ability to do any planning for your parents, right? It's your parents who have to engage the lawyer, and your parents who have to kind of take that initial step to do the estate planning. So, you know, I can kind of personally attest to this. I've had a family member where we knew the father needed to do estate planning. We just knew, hey, he didn't have anything. It would be a disaster if he passed away without doing it. And we kept telling him, hey, you know, you got to see a lawyer, you got to do this. And while we understood how important it was for him to do that, the decision to do it was ultimately up to him. And he ended up passing away, and he didn't take our advice. He didn't do the estate planning, and we ended up having a long, drawn-out court procedure because he didn't have a plan in place. But so I would say when it comes to your parents, I think you should probably call us first. Now, we deal with matters involving people's parents all the time, right? If you have a parent who had a trust and they passed away, or if they're too sick to manage the trust now, that is certainly something that we would guide you through and we handle. In fact, that's what I spend about half of my time doing, is not necessarily drafting trust for people, but helping people administer existing estate plans. And so if you think you may fall into that boat, I would certainly encourage you to call us. Now, when I offer a free consultation, like you're going to get the email for, just to be clear about that, I'm really offering it to you to go over your estate plan. And so if you say, hey, I want a free consultation, but I want to talk about my parents' estate plan, that I encourage you to call us first, and we'll be able to determine the best way of handling that going forward. So, but thank you for that question. I'm going to go into my chat here because I guess there's two places you can put questions. There's a Q&A section and then a chat. Once a living trust is done, oh, I already read that one. What is the maximum amount inheritance without taxes applied by the state of California? And how do you transfer an inherited trust from parent to child? That's a really good question. So inheritance tax, how does that work? That's what I'll address here. The inheritance tax is a tax on the transfer of ownership of assets when someone passes away. And in the state of California, we actually do not have an inheritance tax. So from California's point of view, don't tell the lawmakers this, but you can pass an unlimited amount of wealth in California, and there's no state inheritance tax. There is, however, a federal estate tax, and that applies no matter what state you live in. And the threshold for how much wealth you can transfer without paying that inheritance tax is quite high today. It's about $11.4 million per person, which means if you're a person, when you die, that's how much you can leave to however many people you want combined without having to pay any tax. So each individual person gets what we call an exemption of $11.4 million. And that number is indexed for inflation. It goes up a little bit each year. And interestingly, that high threshold traditionally was much lower than that. Traditionally, that was like a $600,000 threshold. And so if you're a person who did your trust or developed your estate plan several years ago when that exemption was much lower, it's a really good idea to meet with a lawyer now and evaluate if those provisions in your trust are still up to date in light of the fact that the tax law is so different now today. So I'm going to sign off, guys. I really, I had fun doing this presentation. I think this was a kind of a cool one. I hope you guys found it helpful. And I know all of you are going to take me up on my offer to have a free consultation. Why wouldn't you? So I'm looking forward to meeting each one of you. Hopefully you guys get to see how easy it is to do this estate planning from your house. And I wish all of you just a very safe future going forward. And thanks for joining us today. We'll see you all soon.